I'm the odd one out now, Mark. You've put your jacket on.
I did, yeah. There you go. I don't know. Yeah, if we're going to start now.
Okay, shall we?
Okay.
Okay. Welcome everyone again. And last Tuesday, we had the first webinar, which is co-organized by SMU and LMAA as part of the celebration of the 60th anniversary of LMAA, which is a wonderful event. And today we'll have the second webinar. Then next Tuesday we'll have the third webinar. Then each webinar will have a unique and a fantastic theme. Last week, if you can recall, the theme is shipbuilding contract issues. Then this week's webinar, as led by Mr. Aston, then Mr. Gunn and Mr. Sachs, the theme is the latest development of the English shipping law. Those three wonderful speakers will address that issue or those issues from different angles, including the COVID-19 impacts on the shipping contracts and their performance. Then, above all, let me introduce Mr. Clive Aston, the first speaker of today's webinar, and also the moderator of today's webinar. I will disappear very soon. Clive is the past president of LMAA, London Arbitrators Association, Maritime. Then Clive has been a full-time arbitrator for many, many, many years. And before that, Clive was a leading figure in the P&I class. So Clive has wonderful experience in dealing with those shipping matters, all kinds of, including today he will share with us his knowledge and experience in the charter party issues concerning consumption and speed. So now I hand over to today's first speaker and moderator, Mr. Clive Aston. Clive.
Thank you very much, John, and a good welcome to everybody. Good afternoon in Shanghai and the Asia Pacific region, and good morning to people in the West. This year marks the third year of the cooperation agreement between LMAA and the Shanghai Maritime University. And in the normal course, we would be over in Shanghai to deliver this seminar. But for obvious reasons, this isn't possible this year. But I think that the webinar illustrates how quickly the technology has developed in the last year. And it enables us to hold this event in the same way as it has enabled arbitrations to continue to take place, even those involving an oral or what is now called a virtual hearing, with very little disruption. But before we proceed with the papers, I would like to just thank a few people who have been very instrumental in putting today's event together. Obviously, I'd like to thank the Shanghai Maritime University, but also I'd like to thank the Shanghai Bar Association, the Shanghai Arbitration Commission, the Shanghai International Shipping Institute, and the Shanghai office of the World Maritime University, all of whom have offered their support to this event and for whom we're very grateful. Now, as John, and also I should add, great thanks go out to John Lin, who has coordinated all of the efforts that have made this series of webinars possible. Now, as John said, last week, in the first of our series of 3 webinars, we focused on shipbuilding issues. Next week, we're going to be focusing on the procedural aspects of arbitration. But this week, we're looking at charter party and some bill of lading issues. And we have quite a varied bill of topics to get through. And I will introduce our speakers, Richard, Gunn, and Mark Sachs, as they come to deliver their papers. The first paper that we're going to be delivering is, in fact, my paper. It's on speed and consumption claims. And if I could ask for the first slide to be put up on screen, please. One of the obvious questions that I think people ask about speed and consumption claims, and if we can switch to the second slide now, is why are there so many speed and consumption claims? After all, this is not a new topic. There have always been speed and consumption claims under time charters. So why isn't the law clear? And why isn't it easy for the parties to follow? And why do we have to have so many arbitrations to resolve these disputes? Well, I put on screen some of the reasons, I think, for this. There are very, very many different speed and consumption clauses. And frankly, there's very little consistency between them. Very often, these clauses are drafted by the parties themselves. They're often amended very slightly by the parties by adding new parameters. So, for example, in recent years, we've seen references come into these clauses about currents, about the vessel sailing on an even keel, what its draft might be, no deck cargo. And I think it's true to say, without being too cynical, that very often these clauses are drafted to create ambiguity. Quite often when a charter is being negotiated, there may be a bargaining power that one party enjoys over the other, but nevertheless, some small change is attempted and introduced by the other party to give themselves the chance to argue something at the end of the case. So these clauses illustrate the type of provision where the parties are often negotiating for ambiguity rather than certainty and clarity. Another reason that you'll see, and I'll be going through these briefly this morning, is that there is within the industry confusion over the different measures of sea and wind conditions, and in particular in relation to sea conditions and the standards of the Douglas Sea Scale and significant wave heights. The facts in speed and consumption claims are almost always in dispute. There is usually a conflict of evidence between what is in the vessel's logs and what the weather agency say may have been the weather conditions that prevailed on each day. And quite frankly, there is often a difference between the analysis and the interpretation of weather conditions by the different weather routing agencies employed by usually the charterers. And what one sees increasingly now is that it isn't just the charterers who employ weather routing agencies, but also the owners. So arbitrators are faced with two very often conflicting reports of weather routing agencies, both of whom are probably being given very different instructions in order to suit the customer's requirements for each voyage. Another point I think which is important to understand is that it is actually very difficult to assess the impact of sea and weather conditions on a vessel's performance. One is looking here potentially at very advanced issues of naval architecture that would just be too expensive to be considered in a relatively modest speed and consumption claim. So there is always an element of simplifying what is actually quite a complex technical area in order to find a solution within the confines of the speed and consumption clause. Next slide, please. So what is the value of arbitration? What is arbitration adding to speed and consumption disputes? Well, very few speed and consumption claims go to court. And so the awards of arbitrators fill the gaps between the issues that have been considered by the courts. The way I would describe it is to say that the court decisions provide a framework, but arbitration awards fill out the details within that framework. The courts very rarely look at the facts of cases. Arbitration awards consider in great detail the evidence of the vessel's logs, the weather routing agency, quite often looking at periods of a small number of hours, less than a day, to assess the technical details of the vessel's performance in a way that the courts would never do. Arbitration awards really reflect the day-to-day application of the principles, but adopting the individual variations of the clause that may be involved in a case and the particular facts of performance. And when one looks at the body of arbitration awards, one is seeing that it's through arbitration awards that the law relating to speed and consumption claims develops and evolves. And that really is how, or one of the great values of arbitration awards, the changing trends of thought in these areas. Arbitration awards hopefully give you some guidance as to the type of result you may get in any case where you find yourself in dispute with another party concerning the vessel's speed and consumption. Next slide, please. Well, what do we know from the cases? Some things I'm sure everybody watching here knows automatically. Generally, the warranty of speed and consumption applies on delivery and is not a continuing one, although more and more we're seeing now clauses in contracts that make the warranty a continuing one. The term about, well, that normally means half a knot on the speed and 5% on the consumption. And then we come to what I call the framework cases. And if you look at a weather routing report, normally these cases will be referred to in the methodology section of that report. The cases of the Didymi and the gas enterprise. And these confirm that the approach to be adopted is to assess the vessel's speed and consumption in conditions of contractually agreed good weather conditions, and then apply the average speed in those conditions to the whole of the voyage, extrapolating, as the term would be, the vessel's performance in good weather conditions on the basis that if a vessel can't perform in good weather conditions, there must be the same deficiency over the whole of the period, whatever the conditions experienced. Next slide, please. Well, let's look at the first of those points I mentioned, the no continuing warranty. And at this stage, I'll start to look at some of the arbitration awards and how they've filled the gaps within the framework. Now, obviously, in doing this, I can only give a fairly superficial run through of some of the points, but I hope that you'll be able to take them away with you and perhaps sort of develop your understanding through reading the cases themselves. To go through in detail would take up all 3 of the webinars in this series. So, starting with the well-established principle that the warranty of speed and consumption applies either at the date of fixing or delivery into the service. This goes back to 1978 and the case of the Apollonius. Now, as I say, you can provide for a continuing warranty, but it does require specific wording to do so. Now, obviously, the question arises, well, if the warranty applies at the date of fixing or delivery, does that mean that you can only look at the vessel's performance before delivery and you can't look at the vessel's performance after? Because that would seem to defeat the idea of being able to make a claim for the vessel's performance during your service. And the answer to this is obviously no. And in the London Arbitration 418, and these are all cases that are reported in the Lloyd's Maritime Law newsletter, and to some extent in the textbooks now on the subject. It was held that, and this involved a time charter trip, and it was held that the vessel's performance on the only voyage performed under the charter is likely to reflect its capability at the time of fixing or delivery. Now, I suppose this is a fairly obvious point, that if you're only performing one trip, it's very unlikely that there will be a difference between the vessel's capability when performing that voyage compared to its capability when the warranty strictly applies. So usually if a vessel underperforms during a time charter trip, it's likely that there will be a claim that can be pursued because that will reflect the capability covered by the warranty. Now, in the context of a longer term time charter, the vessel's performance on the first and perhaps second voyage is likely to be important in considering what its capability was at the time of delivery. But as you get further into the charter, so the vessel's performance becomes less relevant because one is moving further and further away from the time of the warranty. Now, this can be significant where you have a chain of charter parties, because you may find that after 4 or 5 months of performance in a time charter, a vessel is sub-time chartered out. Well, by that time, the warranty will have largely faded under the head charter party through the passage of time. But in the context of the sub-charter party, the warranty is only beginning when the vessel is delivered. So the charterer who charters his vessel out may find that he can face a claim from his charterer, but then not be able to pass it on to the owner. Now, as a footnote, London Arbitration 418 was also important because the clause in question there included the terms without guarantee. And the tribunal confirmed that just as in other areas, so here the term without guarantee meant that there was no warranty and a very high level of proof was required to show that the owners had misrepresented the vessel's capability when describing the vessel for the service. Next slide, please. The term about. For some time, there was controversy as to whether you could apply the term about to both speed and consumption, because potentially if you did so, there was quite an allowance made in favour of the owner for the vessel's performance. Well, this controversy, I think, has largely worked itself through now, and I think it's pretty well established that where a clause describes the vessel's speed and consumption as qualified by the term about, then that allowance applies to both of those parameters, both speed and consumption. And this was most recently confirmed in London Arbitration 2118. And that was actually quite an interesting one because the clause, as you can see, provided there for the vessel to perform at about 14 knots on about 29 IFO. Warranties up to Beaufort 4, Douglas Sea State 3, with a tolerance of 5% about. Now, the charterers there argued that the expression a tolerance of 5% meant that there was only one tolerance allowed for the term about. But the arbitrators said no, the parties had qualified both speed, about 14 knots, and consumption, about 29 tons IFO, and therefore the allowance was to be made for both. Next slide, please. Another area of uncertainty, and I think an important one, is the different measures of sea state. Now, for wind, things are fairly straightforward. Usually a charter will provide for conditions to apply in Beaufort 3 or Beaufort 4, and that's largely uncontroversial. Where the controversy arises is in relation to sea state, because clauses now will refer either to Douglas Sea State, which is a range of heights, and for example, Douglas Sea State 3 is a range of heights for waves of 0.5 meter to 1.25 meters. But increasingly also, clauses have started to refer to significant wave height, which is a different measure of height. It's an average measure of wind waves and swell waves. And quite a lot of confusion has arisen over the application and the relationship between these two measures of sea state. Next slide, please. A good example of this was London Arbitration 619, where, as an example of where the parties had played around with the clause and introduced their own language with the result that it created confusion, the clause said good weather conditions are understood to mean, which is encouraging because one hopes that the parties are defining clearly what they mean. But it then went on to say total combined sea and swell, significant wave height, confined to limits of Douglas Sea State 3, 0.5 to 1.25 meters. Well, here the parties were using both of the measures of sea state, significant wave height and Douglas Sea State 3. And the tribunal found that the two didn't match. And the case highlighted the uncertainty in relation to the language that is used in this type of clause, because there's no objective industry standard or accepted rule of how to convert significant wave height into Douglas Sea State or the other way around. They're different measures and there's no conversion formula. Now, although it's often suggested that Douglas Sea State 3 is equivalent to a significant wave height of 2 meters, and some of the weather agencies will have you believe that, there's actually no technical evidence of this. And in this particular case, the weather agency acknowledged that. So the arbitrators were forced to look at the wording that was used by the parties and to try and find, as a matter of construction, a way through the confusion. And in the end, they decided that the good weather here extended to significant wave heights of no more than 1.25 meters. So they were looking there to combine the references made in the clause. Now, the result for this, I suspect, is that the charterers and the owners ended up with a far tougher regime for measuring the vessel's performance than they would have expected. Next slide, please. Currents is another very important area. Typically, weather routing agencies will deduct a favorable current from the vessel's average good weather speed. Now, is this right? Usually a clause will refer to no adverse currents. So if there are following currents of 0.5 knot, does that mean that the vessel's average speed is to be reduced by 0.5 knot? Well, the better view is that this is not the case. And there are 3 arbitration awards that I've referred to here that confirm this, that it's only adverse currents that will be taken into account. So if there are following currents, then on the whole, that is a benefit that the owners are entitled to take advantage of. And what the tribunal found here is that the warranty concerns performance in good weather and sea conditions. Now, that includes periods when there are favorable currents. What is excluded is only periods when there is adverse currents that slow the vessel down. Next slide, please. I mentioned earlier that there has always been disputes between the evidence in a vessel's logs and that in a weather routing agency report. The traditional view is that unless there is evidence that the logs are inaccurate, they will be preferred to weather routing agency reports. Again, London Arbitration of 2018 confirms that that is still the case. Quite often, though, the clauses will state which of the logs or weather agency report is to be preferred. Sometimes it will say that there is to be a second weather agency and the average of the two is to be followed. But the difficulty then arises as to whether the weather agency follows the methodology of the clause. So it isn't just a question of taking an average, you have to check whether the weather agency report conforms to the way of calculating speed and consumption that the parties have agreed. There are also questions as to how accurate will weather agency reports be. In London Arbitration 2719, the tribunal found that although the weather agency reported weather at 6-hour breaks, there was the potential for there to be 3, 4, or 5 hours of bad weather between those 6-hour measurements, and therefore the tribunal rejected the evidence of the weather agency report as being unreliable in that case. Next slide, please. There's also the question as to how long a period of good weather is necessary to consider a vessel's performance. Well, the Ocean Virgo is a court case, and there the court found that the arbitrator, who had said that a period of less than 24 hours could never be long enough, was wrong. A period of 24 hours could be enough to consider the vessel's performance. But it's then a matter of degree, because in London Arbitration 2719, it was found that less than a day was an insufficient sample to assess the vessel's performance over a voyage that lasted more than 7,000 miles and lasted more than 25 days. So it's always going to be a question of degree as to whether there is enough good weather time to properly assess the vessel's performance. Next slide, please, and this is the final slide. And this is put in really just to illustrate that the type of claim that can be raised on speed and consumption is never closed. There are always new types. And this reflects a couple of recent arbitration awards that are as yet unreported. In these cases, the charterers had no basis for making speed and consumption claims under the speed and consumption warranty because there wasn't enough good weather. So they followed a different approach. The vessel's hull had been admittedly fouled on delivery. They said that that was a breach of description of the vessel. It was a breach of the requirement that the vessel would be in a fit condition on delivery with a clean hull. They said, well, we have had a model made of the vessel's performance. And by this model, we say that if the vessel's hull had been clean, she would have gone 1.2 knots faster than she was able to do. We accept that there wasn't any good weather, but there was a breach of a totally different provision in delivering the vessel with a fouled hull. Therefore, they made a deduction from the hire to reflect what the model said the vessel would have been able to do if the hull had been clean. Now, the arbitrators there decided that, yes, there had been a breach of the fitness of the condition of the hull on delivery, but the charterers could not put themselves in a better position than they would have been under the speed and consumption warranty. That although there was a breach, it could be only assessed by reference to the standard of performance that the parties had agreed to. Therefore, the parties were locked in to the conditions that they had agreed were to apply in considering the vessel's speed and consumption, so that there was no claim at all. This is just an illustration of how I'm sure that in a year or two's time, there will be further types of claim that we will be looking to consider. It's always changing, but the important point, and the last slide, please, in all of this, is to make sure, if we change the slide, please, is to really to make sure that if you're looking for certainty, that you look for clarity in the clause, both clarity in the parameters that are to be applied and in the method of calculation. Now, for many of you, I suspect the preferred view will still be ambiguity, and one will go back then to the point I raised at the very beginning, but this really is why there are so many of these claims. But hopefully this provides you a little bit of guidance as to how arbitrators approach them now. Thank you very much on that. What I would like to do now is introduce the second speaker this morning, and that is Richard Gunn. Richard is a partner of Reed Smith, and he is the lead lawyer in their global casualty and admiralty team. And Richard has worked on a number of claims involving complex container casualties, logistics, bunker disputes, a wide range. And in doing so, he's been able to bring his experience as a qualified master mariner who spent 12 years on different types of ships and then 5 years ashore operating a fleet of time-chartered bulk carriers. Now, Richard is going to speak to us today about a case that's gone to the Supreme Court. It's very rare for cases to go to the Supreme Court. And so I think this case that Richard is going to speak about is worthy of the publicity that it's getting now. Richard.
Thank you very much, Clive, and thank you all for attending here. Can I have the next slide, please? Nope. Maybe I have and need to change my screen. Forgive me. Maybe not. Thanks. Thank you. Yeah, next slide would be nice. Thanks. And while that slide's coming up, which is about structure, I'm just going to give you a little bit about the facts of the case. Normally, by the time a case has got to the Supreme Court, the facts have become almost irrelevant and the issues are finely focused points of law, and nothing's different about that here, except that I think the facts are useful to understand how the decision has already affected the approach of legal practitioners, and ultimately, if the Supreme Court upholds it, we say, will necessarily affect how ship owners themselves will need to conduct their everyday operations. It's of that level of importance in my mind. So next slide, please. Briefly then, we're going to get on to the facts, I hope. This concerns a vessel called the CMA CGM Libra. So an old case. She ran aground back in 2011, in May 2011, with about 6,000 containers on. She was leaving a port in China. Forgive me if I mispronounce the name. She was leaving GMN in China for an outbound trip, where her next port was Hong Kong. Next slide, please. What I'd like to show you here is just a brief overview of the chart. You can see where the channel is. The channel runs from the top left-hand side diagonally down to the bottom right-hand corner. And Gwing Yao that's what the chart would have looked like and should have looked like back in May 2011. Next slide, please. Just a little bit of detail there. You can see that the vessel has chosen to leave the channel being where the Dow bit is, and he did so because of the 14-meter patch which encroached into the channel area. The ship was drawing 15.5 meters, but of course there would be a height of tide to apply to that chart. In fact, he got his maneuver wrong. He was going to go round that buoy, the red buoy at the top of his track. He was going to go around that buoy and cut between these two buoys, but he didn't do it correctly and got himself into a bit of difficulty. Next slide, please. So what we see now is that he's faced with this small rock in front of him. He can't get between the rock and the buoy off to his port side, his left-hand side. So he sees plenty of water up ahead and thinks, do you know what, I'll just go down there, everything will be fine, and I'll be able to rejoin my track once I've gone past this particular island. Next slide, please. In fact, it turns out that there was an uncharted shoal in that area. So instead of there being 35 meters, there was down to around 4 meters or so, between 11 and 4 meters. Across the entire breadth there of where that circle is, it was very, very shallow water. And unbeknown to him, of course, until he realized that he wasn't going anywhere, that's where he ran aground. Next slide, please. Just to show you what it looked like, this is a picture of the ship's actual chart. You can see he's marked on there his course line going down the channel, both in and out. 139 you see at the top left-hand corner, 318 over on the right-hand side, and you can see his positions marked on there and various chart corrections on the right. That was the chart that was actually in use at the time. Next slide, please. So what happened next? He engaged a salvors from China, part of the China Rescue and Salvage Group, who came out and did a good job in salving the vessel. It took about 10 days. There was a storm coming through and they managed to get it refloated and away before that happened. The owners, instead of allowing cargo to pay for the salvage themselves, or cargo's proportion of salvage, owners declared general average, paid for the full salvage themselves, and then sought to recover from cargo in general average. In fact, security was provided by pretty much all of it, and the cargo was by and large represented by the usual London cargo, experienced cargo lawyers and claims handlers. Most of the cargo interest settled. They accepted that the reason the vessel ran aground was an error in navigation defence, and therefore they paid up. We gave them a small discount of about 1.5% just to cover their costs. However, a small number of the cargo interests decided that they were going to have a crack to see if they could not pay their proportion, and so brought a claim against the owners in the High Court under their security documents for a declaration. Now, cargo asserted, sorry, next slide, please. So cargo asserted everything about that they could in relation to unseaworthiness. We said, as I mentioned, this was an error in navigation. He ran aground on an uncharted shoal, and arguably there was no error at all, in fact. But at worst, his errors occurred earlier on, if you remember, when he made some mistakes trying to get round those buoys. We said there was no reason for him to have known that there wasn't clear water and he was entitled to be there. Cargo interests made all of the unseaworthy allegations that you see there, and either withdrew them or failed at trial in relation to them, apart from the allegation of a defective passage plan. If you're unfamiliar with what a passage plan is, a passage plan is the document that those on board, the navigators on board, must prepare to navigate the ship safely from berth to berth. They will use the charts, obviously, these days electronic charts, and those days paper charts. They will read the various nautical publications that they have on board, explaining routes and dangers along the way. They will consider the weather, the stability, how laden the ship is. All of those sort of aspects and decide where the vessel is to go, and they will then write that into a passage plan and update it during the voyage should they need to do so. Here, it was said that there was something wrong with the passage plan in that the master had not written on the passage plan references, express references to what was called a notice to mariners, which warned that there were depths outside of the channel which could be less than those charted. Next slide, please. We said that the master's actions in that sense were reasonable. He had in fact referred to the temporary notice. There was a handwritten on the chart was see preliminary notice XYZ, and the preliminary notice was indeed beside the chart in a folder, and those were all findings of fact by the judge. So we said he had done all that he needed to do to bring the attention to the navigators of those warnings. And we said furthermore that in any event, the due diligence obligation of owners did not concern the actions of the crew as navigators, and we'll look at that in a bit more detail as we go through this talk. Cargo, though, asserted to the contrary, as you might imagine. They said no, the passage plan was defective in the sense that it was a required document, and that the owners didn't exercise due diligence and could not rely upon the failures of the master and second officer. We can't rely on their negligent failures to do this passage planning. Furthermore, they said it was causative, as if it had been written on there, then the master wouldn't have left the channel in the way that he did. Next slide, please. So what did the court in first instance find? Well, we lost, it's fair to say. Justice Tier, a very experienced Admiralty judge, and in fact, it was him that raised the issue of defective passage plan. It wasn't properly pleaded, and the pleadings were all done subsequently in writing. But the court found that yes, the vessel was unseaworthy before the commencement of the voyage due to the passage plan. He said that a passage plan was equivalent to a chart, and a chart is well accepted trite law that you needed to supply a ship with proper charts. And if you don't, the vessel can be unseaworthy. He applied the McFadden test of unseaworthiness, which I'll examine in a moment or two. And he also went on to find that this was owner's failure to exercise due diligence. And he found this even though he also found that the owners had otherwise provided a fully seaworthy ship. There was everything on board that a prudent sea owner should have. There were the correct charts that were all corrected, there were proper procedures, it had been audited, and the crew were competent in order to carry out their tasks. But he said that the duty was non-delegable prior to commencement of the voyage, and we'll look at that as well, and therefore the negligent preparation of the crew amounted to owner's negligence prior to commencement of the voyage, and therefore we could not recover general average contribution. Next slide, please. So just to pick up on the McFadden test, as it's known, this is Justice Tier's rendering of it. The McFadden test is essentially that a ship will be unseaworthy if a prudent ship owner would send his ship to sea, but would have required the defect to be made good before the vessel set out to sea. That defect needs to be causative. So, for example, a vessel which runs aground through a failure of its compasses could be rendered unseaworthy. But if in fact there was nothing wrong with her compasses and she ran aground for some other reason, then she wouldn't be unseaworthy if it was nothing to do with the ship, even if, for example, her anchors would have rendered her unseaworthy in some other circumstances. There has to be a causative element, and the owner, if the owner would have known of it, would he have required it to be made good? That's the McFadden test, and Justice Tier cites it there. Next slide, please. Sorry. As for due diligence, then, this is the Muncaster Castle case. And what the Muncaster Castle essentially says is that an owner can't rely on the negligence of his servants when exercising due diligence. The obligation under Article 3, Rule 1 of the Hague-Visby rules is that a owner must exercise due diligence to provide a seaworthy ship before the commencement of the voyage. Under Article 3, Rule 2, which is to do with carrying the cargo and, if you like, being on voyage, he's entitled to rely on the defences in Article 4, such as, in this case, error in navigation. But that doesn't apply in Article 3, Rule 1. The duty is to exercise due diligence to provide a seaworthy ship. And the test and the law is clear that that duty is non-delegable. And what Justice Tier said was that he cites the test as you see it there. However, as we'll see, we say that this relates to attributes of the ship, and the actions of the crew in what they do are not attributes of the ship, and the passage plan itself is not an attribute of the ship either. Next slide, please. So those were the two grounds that we sought leave to appeal to the Court of Appeal, which we obtained. Did they hold that a one-off defective plan rendered a vessel unseaworthy? And furthermore, then, as regards due diligence, were those actions of the master and crew carried out as navigators, or were they carried out effectively as agents of the owner in providing a seaworthy vessel? And we'll examine those in a little bit as well. Now, if we could have the next slide, please. I'm not sure if the next slide's come up yet, but I'll carry on. On the seaworthiness point, what we say is that this defective passage plan can't be a defect under the McFadden test. That concerns, as I say, the attributes and conditions of the ship, such as charts, compasses, steering gear, watertight tanks, ballast pumps. There are lots of cases that deal with this, where there has been prudent owners must send ships to sea, and equally so in relation to the Muncaster Castle test. We say that the passage plan is not equivalent to a chart. A chart, if you want to go out and buy a chart, you get the chart fully corrected and they will all look exactly the same. That's what it is. But a passage plan is not a science, it's an art form, and any particular mariner will draw it up in a different way to a different mariner. And the reason that that is important for this case is because all of these cases will now allow there to be argument as to whether or not the passage plan for the particular voyage was satisfactory or not. And if there is an argument about it, there's probably going to be a settlement about it. And if there's a settlement about it, then that is redistributing the insurance burden from cargo towards ship owners. So next slide, please. So on that point, then again, if I can't stress this too often, I suppose, its owner's capacity as carrier. So if you think about what the owner would do to his ship, we say that that's where the Muncaster Castle applies. If the owner he can't rely on the negligence of other people doing things to his ship. But where people are doing things with the ship, then that is not something for which he is responsible, providing he's provided a competent crew. How the master then deals with the ship, the seaworthy ship, is not a question for him, and he should, it takes it out of Lancaster Castle type considerations. So next slide, please. The timing of the issues and errors is important, and as we'll see, this has been picked up on in a legal perspective. Difficult decisions, because where the owners can rely on providing a competent crew, and nevertheless they make an error in the moments after the vessel has left the berth, that would be a complete defense to the ship owners. However, where they have made navigational errors prior to departure, even though he's provided a competent crew, he can't rely on those under the way formulation of Justice Tier, and now it's fair to say the Court of Appeal as well. So we say that's another reason why the preparation of passage planning is an issue to do with navigation, and therefore not an issue for which owners, as owners of the ship, can be responsible, provided they have done everything in respect of the ship to make that seaworthy. Next slide, please. So off to the Court of Appeal we go, and it's fair to say an experienced shipping panel, and they found against us for slightly different reasons, each of them, and we'll look at those reasons now, if I may. Next slide, please. Haddon Cave took the view that for him, everything that happened prior to the vessel setting sail is essentially owner's responsibility. After that, he can rely upon the defences, to the extent anyway that he's exercised due diligence, he can rely upon the defences in Article 4. But before that, there would be very few, if any, things upon which the non-delegable duty would be an excuse. So the negligence of pretty much everybody is something for which he is responsible, for which owners are responsible. That was the basis, primary basis of his decision. Next slide, please. Lord Justice Mayles looked at the attribute of the ship point of view and said that he saw the passage plan as being an attribute of the ship, equating it to a chart essentially, and saying that therefore if there wasn't if the passage plan was defective, then that was just tough, and therefore the vessel was unseaworthy. And although he recognised that it was new law in that there were no cases, he actually thought, well, that just means presumably that people have been happy with it before, and applied the well-established principles, equating it to a chart. Next slide, please. Lord Justice Flo took a more robust position throughout the hearing, it's fair to say, and he sort of moved away slightly, as you can spot in this paragraph, this quote we've taken, because he's moved out of the passage plan to a certain degree and is referring instead to the working chart on the basis that it is trite law that a chart is necessary, a properly corrected chart is necessary for a vessel to be rendered seaworthy on departure. So here he says that the failure to write on the chart, which was identified by Justice Tier, rendered the chart defective, and that makes it easier for him to find that for that reason the vessel was unseaworthy, although the failure to write it on the chart is, we say, an aspect of passage planning, because the fact of the correction recording the temporary notice was already on the chart. Next slide, please. Looking at different decisions, because we said there were no decisions, but there was a sort of quasi decision from the Fifth Circuit. I apologise for the typo, not the Firth Circuit. So there may well be a Firth in the US, but I'm not familiar with it. And in looking at that, Flo said that it would be inconsistent with English law, which is that an error in navigation before or at the commencement of the voyage is capable of rendering the vessel unseaworthy. But we say that is precisely the point. There is no English law until this case that an error in navigation was capable of rendering the vessel unseaworthy. And it seemed an odd structure in which to reach a conclusion that he did. Next slide, please. So just briefly, I'm aware of time, just commenting again there, what on Haddon Cave's point, he referred to the division of the allocation of risk into two separate regimes, the so-called temporal delimitation. In other words, everything that happens before is owners, and everything that happens after owners, they can rely on their defences utterly. We query whether or not that was the intention back in the Hague Convention, giving rise to eventually the Hague-Visby rules, which applied here. And whether or not it should, in fact, it is a distinction between what people do and what aspects of what people do owners have control over. Next slide, please. We have permission. We sought leave to appeal to the Supreme Court. They've regarded that as being, this case as being important enough for them to warrant having a look at it. The international group of P&I clubs intervened in our seeking leave to appeal. That's a process within English law where a third party, an interested third party, can say that they think their lordship should look at this because for them it's of interest too. And for the international group of P&I clubs, obviously it is of importance to them because previously, as I mentioned, where one has a general average for this type of case, a grounding or whatever it may be, and one seeks to rely on error in navigation, owners can generally, or used to be able to, rely on that so long as they could show that they provided a competent crew in the sense that they'd exercised due diligence with their recruiting processes, and so long as their systems and everything was fine. In those circumstances, the cargo interest would pick up cargo's proportion of GA. With this new case, that now seems to be in doubt, and in which case then the P&I clubs are liable for unrecoverable cargo's proportion of GA, and therefore the burden, as I say, has shifted into the mutual societies, away from general insurance and into the mutuals, which is obviously of huge importance to them. So next slide, please. The grounds for appeal are pretty much the same as they were in the Court of Appeal, namely the meaning of seaworthiness and whether that is an attribute of the ship, and or whether or not the crew themselves can be found, if you like, non-agents of the owners when carrying out aspects of navigation, which we say should be the case, and indeed has always been the case in the 150 or so years that these cases have been heard in the commercial court. So it's a very important case, and 8th of July, I think, is the hearing. It will be streamed live, as these Supreme Court cases are, and if you're interested, you may find it an interesting experience to dial in and watch the various performances taking place. So thank you for listening, and that just about brings me to the end.
Thank you, Richard. And we will, at the end of these talks, be having a question and answer session. And so it would be interesting to hear any comments in particular from the P&I clubs on the implications of the case. Let's move on though. Almost inevitably at this time, there's going to be a paper on the effects of COVID. And the person who is best placed to deliver that to us today is Mark Sachs. Mark is a partner of Penningtons, Manches Cooper in London. He was heading up the firm's Singapore office for 10 years. Will be known to many of you in Shanghai as a regular speaker over there, in no small part because he's a fluent Mandarin Chinese speaker. And he actually worked in Shanghai as a maritime lawyer earlier in his career. Mark is going to take us through some of the effects and consequences of COVID, particularly in the context of time charter parties. Mark. Are you unmuted, Mark? Mark, are you unmuted?
I'm there now, thank you. 大家你好，我还是用英文这次，因为我们是做那 LMAA 的讲座。So I will use English. I just thought I would say hello in Chinese. I am going to share my screen for this, and indeed make sure that happens. And that was why I didn't unmute initially, because it didn't quite come up. So are you now seeing my screen?
Yes.
Okay, good. My talk is on the impact of COVID-19 on the shipping industry. I want to deal primarily with charter party issues. There are other issues, and there are certainly, I think it's fair to say there have been practical issues that have come up as it's progressed, particularly with crewing. And we shouldn't forget really just how much, of course, the industry is dependent on crews, and they have had trouble, of course, because of travel restrictions and quarantine in terms of being replaced ordinarily under contract. So many crews have stayed on board longer and served longer than they might have, or have had difficulty then changing. And it's been an issue for owners. I won't talk about that. It hasn't had a huge impact on the legal side, but it has been an aspect that has created problems. One thing I did want to deal with, though, now, let me see. All right. I need to, I think if I go to full screen, there, I think you can see things a bit easier that way. Does that work a bit better in terms of the size of the text? Yeah. I wanted to talk, this is not directly a shipping case, but I think it highlights, I think, why in some respects, the LMAA is doing these kinds of talks, because what happens in the English courts has an effect commercially and in the insurance industry. So a decision about COVID-19 was issued since I prepared my slides, and it came out a week ago. And this is a special kind of case procedurally. The Financial Conduct Authority, which regulates insurers and the financial industry, but the insurance companies are part of what they do. There is a fairly new procedure that allows reference to court by the Financial Conduct Authority to seek rulings on policy wordings and other aspects of regulation. And so in this case, in June, only in June, so a case was brought by the Financial Conduct Authority, and there's a special provision in the English procedural rules now for two financial judges or judges with a special background, to hear these cases. And this case then looked at clauses involving 8 insurance companies. And it was about business interruption insurance, and where either, say, if the business has not been able to continue because of COVID, or say a premises can't be accessed because of a lot of the lockdown measures that occurred, and whether the insurance policies would respond. And the case at this level found that the disease exclusion in the clauses generally meant that the COVID losses were not covered. There were a couple of the clauses where it was not as clear, and the decision was that it may be the case. It's a judgment of 165 pages that I confess I haven't read. I skimmed through, but I commend it to those of you then who practice in the insurance area. It will have a considerable impact. And I might then mention as well why I say it's of importance, and to tie it to the LMAA and the function the LMAA serves. It's quite similar in terms of how the English courts are able to respond to topical problems in the industry. And you can draw a similar conclusion from how the res cogitans, which was a case about the OW bunker insolvency that generated probably, Clive, a couple of thousand separate arbitration, it's a very large number of claims, in particular contract in that case referred disputes to LMA arbitration. The insolvency administrators were pursuing many ship owners around the world, and there were many arbitrations and indeed court cases around the world. And the case, though, then was referred on a fast track basis and was heard in a space of months by the Supreme Court, which settled the issues, the legal issues in those cases. And in that case, the English Arbitration Act provides for appeals on issues of law to the court, and that allowed the court to make a legal determination that would assist tribunals. And so it was not then down to each arbitration having to make its own determination and wait for appeals, but it really could set the standard and clarify the law. So this will be similar. Many insurance policies also have arbitration clauses these days, but this will provide guidance on interpretation of those policies by the courts. That was my stop press, or my most recent case and discussion of English law in that context. I am now going to move to my original slides and the issues that are here on COVID for owners and charterers and operators. And of course, most of you in the room, perhaps apart from early students, will know the difference between voyage and time charters. But of course, the impact of COVID is different because of what the two types of charters involve. And if you consider in particular, say, a time charter, the normal stance of the courts and arbitration is that if the charterer has the use of the ship and is directing where the ship goes, generally the charterer is going to be responsible for problems that arise that are particular to where the ship is directed. So that's a particular issue for time charters. For voyage charters, and I think as Richard's talk points out, the problems under voyage charters tend to arise under unseaworthiness, and in particular where often the Hague-Visby rules are incorporated, and so that there is the non-delegable duty, and therefore, as we've been shown in the Court of Appeal, the scope of what that might mean, and it includes crew competency, can be quite wide. The reason I have both of them up on this slide, though, is that in particular for those of us practicing, the difficulty often is that there are in any actual shipment or movement of a vessel where problems arise, both types of charters are often in play, because there's quite often a time charterer from where they are the operator and have chartered from the head owner, and there may be a couple of time charters, but there is often a voyage charter at the end where the actual receiver, importer, trader has chartered the vessel on a voyage charter term to meet the sale contract commitment. And so you usually will have a situation where there are different obligations in the charter chain. And so the parties can be affected differently, and in particular the operator, who may then have time chartered the vessel in. And quite often there will be a party who has time chartered in, but voyage charters out. And they are not back to back, which is the term we use as practitioners. They have differing obligations looking down the chain and up the chain, and that causes problems. Just stopping there as well to talk about how the LMAA has deals with these sorts of cases. There are fewer chain charter cases now. There were in the 08-09 financial crisis, there were often lengthy chains with a series of time charters in between, largely to do with charter rates and indeed the freight futures market that had an impact. The chains aren't as long now, but the LMAA generally, where there are multiple parties in a chain involving a single issue and dispute, or just common dispute or common issues, will try to have them heard together. Parties will attempt perhaps to appoint the same tribunal so that the sort of multiple claims are avoided. So it's also something that can occur in arbitration, and often does, that is a procedural step that isn't available in court. And it's also a reason why charter parties, and why I think owners in the market generally will try and keep arbitration clauses in charters back to back, at least, so that the charters that are in the chain refer disputes to the same law in the same jurisdiction, usually arbitration. So that is a reason for the market to try and keep charters in chain and harmonized as to their law and arbitration clauses. So just to then go to time charters themselves, the problems that arise under a time charter is that ordinarily, and it can even often be implied, but it's usually expressed, that there is a safe port clause so that the vessel will trade only between safe ports. And that is an absolute obligation under English law on the part of the charter. And the vessel, there's a classic test from the eastern city. The vessel has to be able to arrive at, use, depart from the port, absent unusual occurrences, and safely. It has within it that there can be normal dangers that can be avoided by good seamanship, but generally it's an absolute warranty, and it doesn't just apply to physical attributes, but also political ones, or indeed a disease, such as this, if it was unsafe. And it is a danger. The vessel only needs to be exposed to that danger, potentially, to make it unsafe. The charter has an obligation to nominate a safe port, and it needs to be prospectively safe at the time of nomination. Now, we have had cases in our office over COVID involving the safe port warranty, and this was certainly early on when it was just happening, and people weren't yet sure what was happening. We did act for owners who had a vessel that was directed to Italy, just at the time when the outbreak in Italy was was ramping up, and it was unsure what would happen. And a lot of the measures that have now been put in place about distancing and other ways to control COVID were not yet in place. And as I will get to, that charter had a modified clause, the BIMCO infectious or contagious disease clause. And so the owners were in a position to refuse to call, and also could, under that clause, direct the bills of lading not be issued in respect of going to that port, and call on the vessel to require charters to nominate another discharge port. Now, as it's said on the slide, there is English case law not about COVID itself, but about other diseases that they indeed can also be cause or be grounds for unseaworthiness, which also arises under time charters. A time charter, an owner under the time charter has to provide under the NYPE form, which is quite standard, the wording which says tight, staunch, and always fit for service is generally seen as a seaworthiness obligation. There's and it's an obligation it's one of due diligence to make the vessel seaworthy at the outset, and then to take steps afterwards to return a vessel to a seaworthy condition. But at the outset, that can arise. But at any rate, although this was a voyage charter case, it's useful, for English law. And as you know, in English law, the courts will refer to prior cases as precedent for decisions that they make currently. The Campa versus British India Steam Navigation was a case involving plague in 1906 that had broken out in an African country, and the vessel had to call at an intermediate port in France and had to go under a decontamination process, and the cargo on board was damaged by that, and it was found the vessel was unseaworthy because of that that port call and the fact that it had called at a place where there had been an outbreak of a contagious disease. So it has, I mean, what I would say about the time charter aspect is owners, sorry, I have some other sound coming on. Can you hear? Sorry, Clive, I'm hearing somebody, I've got somebody else speaking in the background.
Yeah. John, are we able to silence the background noise? Go ahead, Mark.
Yeah, okay. So what I would say about the position under time charters has been that although in the initial stages there was a lot of concern, practically speaking, as safety measures have come into place and the social distancing that is there, that ports have limited crew going ashore and the people coming on board, the practical situation has been that ships have been able to continue to trade. And there are, I think, we've not had many cases in the office where owners are seeking to or have sought to avoid ports. And so the practical measure, in practical situation with COVID has been that the ships have largely continued to trade without being impeded. Of course, it does take time for cases to come through in terms of arbitration, and I may then ask Clive later. He's probably in a better position to say just how many cases he thinks are coming through that deal with COVID. But from in my practice, there haven't been so far. There hasn't been a lot of disruption that it will likely engender specific cases on COVID. I will talk then about the BIMCO clause itself. Of course, this clause was not drafted with COVID in mind. It has been there for 2015. It hasn't made it into that many charters yet, perhaps, but people and parties may have incorporated it. It is fairly classically, because of what I said earlier about how the underlying principles of time charters, that it is the charter's risk because they're directing where a vessel goes. The clause itself, certainly in the situation of COVID, will favor an owner's position, because if there is a disease, and COVID clearly, I think, falls within the definition, and there's an affected area where there's a risk of exposure to the vessel or crew, then the vessel is not obliged to proceed, and owners can require charters to nominate an alternate port and can require that bills of lading not be issued to direct the discharge or to the place of discharge is not an affected area. So that can then, from a charter's perspective, would be highly problematic in terms of the cost of having to deal with that and the disruption. I don't know how many cases have resulted or where owners have been in this position. As I said, we did advise one owner with this sort of clause. The effect that when COVID is widespread and generally around the world, and although it might be affected now with measures in place, so the question would be, is the port affected simply by the potential presence of COVID? And indeed, there may be questions that, just if, say, it is only in 1% of the population and there are proper distancing measures in place, and all of the port people, workers and customs officials, etc., were tested, or even didn't come into contact, could the clause then be challenged? I'm not sure how that would result, but you can see that because of the measures that are put in place, as I said, the practical effect has been that shipping has, and the ships have continued to trade to affected areas simply because of how spread it is and because of the measures that have been put in place. But there are certainly problems that can arise, because if a vessel, and from an owner's perspective, if the vessel has been directed, say, and called in a jurisdiction or at a port that has been affected, the vessel might be excluded, barred from calling at a subsequent port. And that would be a concern of owners and could again be problematic, and an owner may therefore decide not to call. The early on, those kind of measures were in place. I think there were ports in Asia that were barring vessels that had called in certain areas, and vessels did need to alter and change how they were trading. Again, that's not happened as much in the preceding ensuing months. Sorry, I don't have a clock up. Now I realize that I'm actually running up against time a bit, so I am going to move a bit to just on voyage charters. And again, it's of interest to me to, oh, no, did I? Sorry, I had one other. Yeah. Okay, it's of interest to me on the voyage charter side, and in particular tying this to Richard's talk, because of how unseaworthiness is dealt with. And the same definition, of course, the classic definition that Richard referred to in the Bradley and Sons case as to whether a prudent owner would allow a vessel to sail in that condition is the test, and the Hague and Higgsby rules are usually incorporated. Seaworthiness issues, though, can arise because of crewing and either a deficiency of crew, of course, and so you could have, under a voyage charter, say, crew that are infected and therefore are incapacitated, or they need to be taken off a ship. And if the crew, say, had not been careful about avoiding contact, there could be an issue as to whether they were competent. If the procedures, and this is the sort of wide-ranging inquiry that can arise in the kind of cases that Richard was talking about, such as the big GA cases, where the cargo interests may decide that they want to avoid a cargo claim or GA contribution and will allege the vessel's unseaworthy. And in that situation, I could see it being difficult for an owner to prove that all steps have been taken if there hadn't been good proper measures in place and directions from the owner to ensure that the crew is protected. And indeed, suppose that that the captain had not gone ashore to a restaurant. If it's non-delegable, then he could be responsible for that, potentially under how wide.
Time is up. Can you finish within 3 minutes?
I can. And again, I want to mention one other case, and I had put it up. Oh, there we go. I had put it up on the slide. Because of this decision has also just come out. It is a trial level decision, the Eternal Bliss, and it's a case that my firm acted on. But like Richard, we came out on the wrong end this time round, though it's likely subject to appeal. It has attempted to resolve an issue in English law about damages under voyage charters. And it may have an impact in the COVID situation because there have been two views as to whether a charterer was liable only for delay, and that is of course reduced to liquidated damages for in demurrage, and therefore liable to pay demurrage only, or whether a charterer could be liable for other types of loss resulting from delay without it being shown that there was some other breach of charter. And Mr. Justice Baker came down on the former view that in fact the charters could be liable for other types of damage that arose apart from the loss of time to the vessel that is incorporated into demurrage. That case is also going to appeal, and he gave leave. So that will be an interesting case to watch in terms of COVID as well. So I will conclude there and look forward to any questions. Thank you.
Hi, thank you very much, Mark, your wonderful speech and of course the course materials which we have distributed to the audience contain all your lovely slides. Now, time is very tight and we can only take one question. Actually, the question will be taken and have been taken from Julia Zhu, who is working in a famous club in Hong Kong. And Julia will pose one question, then we'll pass that to the speakers. So now can we have Julia online?
Hello.
Hi, Julia.
Hi. My questions go to Richard and Mark, and it's based on the real situation. Is that a collision took place off Shanghai, and the vessel reported the collision to the local MSA. Normally, it will take the local MSA around 2 days to do the investigation to find out which party will be the liable party and about the liability split. But this time, due to the COVID-19, it took the MSA 30 days to finish the job. So we are wondering that when the ship owner claim their loss of earnings, can they count into all the 30 days into their claim amount? That's all.
Thank you, Julia. Then the question is to Mark and Richard. Who will go first?
I think it sounds like that's a charter question in terms of the actual risk of and I suppose the thing would be that on the collision itself, the vessel was put off hire. And the question will be then, if the vessel was repaired, say, within that time and was ready to sail, does the investigation by the authorities still fall within off hire? And I think that's certainly how I would argue it. And so that the vessel would not come back on hire until it was able to sail, because the authorities were undertaking investigations as they were required to do. Richard, do you have a comment on that?
Yeah, thanks, thanks, Mark. One of the can I first check that Reed Smith aren't involved, Julia?
No.
Okay, cool. The yeah, interesting. As Mark was saying, the question of detention for a collision, of course, is primarily a question of fact to start with. So, if the vessel was under some hire, some sort of time charter, and she was placed off hire, and it seems to me that under the usual rules she would be allowed to be placed off hire, then that would be ordinarily allowable as a detention time. If the authorities have detained the vessel as a result of that collision, then I think that flows naturally and is a direct consequence of the collision. The fact that we're now in COVID times and it's longer is simply fortuitous, or if you like, fortuitous in the sense that it is the situation in which the owners find themselves. I don't think that the other vessel would be able to say, in another set of circumstances, it would only have taken 2 days, and therefore I'm not paying you for anything more than 2 days. And that would have to be the way that would go. They would have to simply say, well, that's what it is. Now, having said that, normally, or often, and it may be different in a particular set of circumstances, a vessel won't necessarily be detained while the local jurisdiction investigative body takes its evidence. Often they'll come on board, get the evidence, and particularly electronic evidence, and go. But if that's not what happened here, if in fact the vessel was prevented from departing while the relevant state undertook its investigations, for me, that's probably a valid detention time.
Yeah, and I suppose you do get some arguments about it in terms of, oh, sorry, Clive. Yeah.
Or
just to finish it. Yeah, I think there are cases where if the authorities were acting in a way that was somehow an intervening cause, you might get a restraint of princes type argument being made, where the actions of the authorities were intervening in a way that was something that provided an exclusion of liability. And I guess in what Richard was saying in the damages context, where the other vessel, say, was disputing whether that loss of time or detention to the vessel is claimable, cause in some way.
I think it's difficult to say that COVID acts as an intervening cause or breaks the chain of causation, or somehow divorces the delay from the collision and liability for the collision in terms of off-hire. John, if I may I just make some sort of closing comments, because you said that this...
No, it's up to you, whether you want to close this session.
Very, very briefly, I mean, just by way of a footnote, I think, to Mark's paper, as arbitrators, we're not seeing that many cases come through yet on COVID. The sense I have is that when they do, we're going to see perhaps disputes about time and bunkers consumed in changing crew, and perhaps the reason we haven't done that yet is that a lot of owners still haven't managed to get their crew off the ships to do the change. But I think there are disputes brewing there. And also under sale contracts for ships, MOAs, where we're hearing of problems, delays, and even the COVID being used as an excuse for not proceeding with the sale of the vessel. So I think we will see cases coming up in the future on that. By way of closing, though, I must apologize for the fact that we all as speakers are perhaps being over-enthusiastic about our topics. But I do hope it's been instructive. What happened last week is that something similar happened, and people wrote in afterwards with questions, and that provoked quite an active question and answer session by email. So please do, if any questions have arisen today that you would like to put to any of us, please do write to John and he will pass them on to us. That said, by way of reminder, next week there will be Neville Phillips, Ian Gaunt and David Martin Clark talking about the new virtual hearing rules that the LMAA has introduced, issues of partial awards and preliminary issues and the advantages of those, and also from Neville Phillips, the important question of clauses that require the provision of documents, particularly in demurrage claims, by deadlines that perhaps are different to the contractual time bar or limitation period. So I hope that as many of you as possible will view that next week. But in the meantime, many thanks. I'm sorry we've kept you longer than we had hoped. And again, many thanks to John, who I'll ask now to close the session for the morning or afternoon. Thank you.
Thank you very much indeed, Clive, and to all speakers, great thanks, and great thanks also to all the audience. Let's meet up again next Tuesday. The same time, 14 p.m. Beijing time. So let's meet up online next Tuesday. Bye-bye for now.
Thank you.
Thank you, Mark, and thank you, Richard, as well as John and everybody in Shanghai.
Pleasure. Thank you very much.
Thank you.
You want us to stay online, John, or are you rushing off?
If you wish.
I'll wait for the
we will wait until the last one. We will be the last one who will leave. So you can leave at any time you like.
Okay. Well, as I say, any questions that you get, please do pass on. And there are quite a lot of questions afterwards.
Yes, we'll prepare a list of queues and we'll pass to you by email probably. Then you get those answers. Then we'll put a disclaimer saying we are not providing any legal advice. We are only providing purely academic reference.
Excellent. Okay then. Well, I'll leave, which may encourage the other participants to leave. Thank you again, Richard.
Bye-bye.
Thanks all. Thanks for the opportunity.
Thank you. Bye-bye.
Okay. Bye-bye. Bye-bye.
Okay.